In this video, we're going to be introducing charitable purposes. Now, in the previous video, we were looking at the legal definition of a charity, and we saw that in Section 1 of the Charities Act, a charity is defined as an institution which is established for charitable purposes only. And in Section 2, a charitable purpose is one which falls within Section 3, subsection 1, and is for the public benefit. So, when does a charitable purpose fall within Section 3, subsection 1? This is what we will look at today. Okay, so the list of charitable purposes can be found within this particular section. And the Charities Act Section 3.1 says that a purpose falls within the subsection if it falls within any of the following descriptions of purposes. Okay, so the prevention or relief of poverty, the advancement of education, the advancement of religion, the advancement of health or the saving of lives, the advancement of citizenship or community development, the advancement of the arts, culture, heritage or science, the advancement of amateur sports, the advancements of human rights, conflict resolution or reconciliation, or the promotion of religious or racial harmony or equality and diversity, the advancement of environmental protection or improvement, the relief of those in need because of youth, age, ill health, disability, financial hardship or other disadvantage, the advancement of animal welfare, the promotion of the efficiency of the armed forces of the Crown or of the efficiency of the police, fire and rescue services or ambulance services, and any other purposes that may reasonably be regarded as analogous to or within the spirit of any purposes falling with any of the paragraphs above. Okay. Now, subsection M then, we're told to include in the list of purposes those regarded as analogous to the above. So in other words, any purpose which may be regarded as similar to any of those categories will be a charitable purpose, as will any type of trust which are analogous to or within the spirit of the old charities law. Therefore, in effect, other types of charitable purposes under the old case law will continue to be recognised as charitable purposes, regardless of whether or not they appear explicitly within the list of charitable purposes in Section 3, subsection 1 of the 2011 Act. So, for a purpose to be a charitable purpose for the purposes of Section 2, it must fall within Section 3, subsection 1. In other words, it must be brought within one of these categories in the list. So for a purpose to be charitable, it has to be within these categories. For example, a trust is established for assisting the work of the NHS. To work out if this is charitable, if this is a charitable trust, we have to look at its purpose and whether it falls within Section 3, subsection 1, and whether or not that brings about a benefit. Okay, so the purpose of this trust then is clearly charitable, as that would fall within Section 3, 1D, okay, the advancement of health or the saving of lives. So you look at the purpose of the trust and see whether or not it can be slotted into any one of these categories in Section 3, subsection 1. If we can, then the purpose may be charitable, so long as it is also for the public benefit, as is seen in Section 2. So the fact that the purpose falls within Section 3, subsection 1 is necessary but insufficient in determining whether or not there is a charitable purpose. Okay, it must fall within Section 3, subsection 1 to be a charitable purpose, but must also be for the public benefit. Now, let's have a little bit look at the backdrop of Section 3, subsection 1. Okay, we're going to actually unpack this section in the next video. This is purely just an introductory video, and I always think that a historical backdrop is always a good thing. Okay, so what is the historical backdrop to these categories listed in Section 3.1? The foundation of the list in Section 3.1 lies in the Charitable Uses Act 1601, otherwise known as the Statute of Elizabeth. Now, this statute was actually concerned with tackling abuse in the administration of charities. So the aim of the statute was not to provide any sort of legal definition of charity or any sort of guidance as to what may or may not be charitable. The preamble to the 1601 Act listed a number of charitable purposes which the 17th century judiciary then used in their determination of charitable status. Okay, so the aim of the statute was to tackle abuse in charity administration, but the preamble to the Act listed a number of charitable purposes which the drafters considered to be charitable, such as the relief of poverty. The judiciary then seized upon that list in the preamble and used it for a purpose it was not intended for. In other words, to help them in their determination of charitable status. So the judiciary used the list in the preamble in order to determine whether a purpose was charitable or not. They held a purpose would be charitable only if it fell under one of those purposes listed in the preamble. Now, while the statute was repealed by the Mortman and Charitable Uses Act of 1888, its spirit lived on in the common law. It is clear the courts have incorporated the practice of allocating charitable status to purposes analogous to the preamble of 1601 into common law. In the Scottish Burial Reform and Cremation Society and Glasgow City Council case, the House of Lords accepted that the case law following from the preamble should be accepted as keeping the law of charities moving as new social needs arise or old ones become obsolete or satisfied. In that case, a trust for the maintenance of a crematorium was found to have been a charitable purpose. Now, over the next 300 years, the judiciary developed the list of charitable purposes. So the list in this preamble did gradually expand. So the courts began, determining that more things were charitable purposes by including purposes that were analogous to the purposes in the list. The preamble influenced this development. A purpose was held charitable only if it fell within the preamble expressly or by analogy. So the charitable purposes stayed rooted in some sense in the Statute of Elizabeth, but it was developed through judicial decision. Now, this takes us up to the present day, where the list of charitable purposes are now placed on a statutory footing in Section 3(1) of the Charities Act of 2011. So, the list of charitable purposes have now been placed on a statutory footing and is now contained within Section 3, as I just mentioned. The Charities Act 2011 seek to displace the importance of the preamble to the 1601 statute in defining the meaning of charitable purposes. Thus, any references to the preamble of the 1601 Act in any documents constituting a charitable trust or company are now to be read as references to the Charities Act 2011, so that it is the new Act which now governs the validity of charities. Statutory articulation has made little difference to the contents of the list. Okay, so the various categories in Section 3, subsection 1, by and large reflect the judicially developed list of charitable purposes as it stood prior to the Charities Act 2006, which was later consolidated in the Charities Act 2011. So what the legislature did effectively was identify the purposes the judiciary had acknowledged as charitable from the various court decisions and then listed them in Section 3(1). So the list of charitable purposes in Section 3 is very similar to the list of purposes the judiciary had already accepted as charitable in the common law decisions. But there are some possible innovations. So there are some differences between the purposes that were accepted by the court prior to 2006 and those accepted in the statute under Section 3. And those are the addition of the advancement of amateur sport. So that can be seen in Section 3(1)(g). So prior to 2006, the court did not recognise the advancement of amateur sport as a charitable purpose. So this is an innovation that came with the introduction of the statutes. And the second possible innovation is the inclusion within the advancement of religion of the advancement of a religion which does not believe in God. That's Section 3(2)(a), subsection 2. So prior to 2006, the court asserted religion necessitates a belief in God, but that has now been changed by the statute. So that would possibly be the second alteration. Okay, so that is the end of this particular video on the introduction to charitable purposes. In the next video, I'm going to start unpacking section 3, subsection 1, so we can really understand the actual meaning behind each or most of the charitable purposes. But if you have any questions at all about this video, then make sure you leave a comment below and I'll get straight back to you as soon as I can. If you enjoyed the video, then make sure you give a thumbs up and subscribe to my channel. Thank you very much for watching.